So welcome everybody to our third and final presentation for today. I'm very pleased to introduce David Fewer, who is the director of CIPPIC. CIPPIC, is that how you would pronounce the acronym? I always have fun with acronyms.
That's what we go with.
So you're an intellectual property and technology lawyer, and you bring a decade of practice experience to the Canadian Internet Policy and Public Interest Clinic's advocacy on intellectual property and technology files. Prior to joining CIPPIC, you practiced intellectual property and technology law with national firms in British Columbia and Ontario, and you clerked with the Federal Court of Canada. And so welcome, David, and the floor is yours.
Thank you very much. I've really got to update my bio. I realized when I was preparing for this presentation that I wrote my first paper on the law and data, database protection in particular, in 1998, so 23 years ago. I've been working on data, intellectual property, and tech law, generally speaking, for a very long time now. It's making me feel old. All right, so my presentation, I just took the title of the day, right? Interoperability, privacy, and balancing anonymity and data utility. If I were to title my presentation, I would go with something like this: How what I do wrecks what you do. A lot of what I do as a lawyer is all about risk management and figuring out what are the legal impediments to doing something that our client wants to do. So just a little bit of background. My job at CIPPIC, I'm general counsel. I am a lawyer. I practice, as you'll find out during this presentation, we go relatively frequently to the Supreme Court of Canada on intellectual property and technology law matters, including data and anonymity and data transactions, as again we'll find out in this presentation. We do quite a range of stuff. Let me give you a little description of what CIPPIC is. It's the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic. We are, or CIPPIC, that's what we go by. It's so much easier to say. We're based at the Faculty of Law at the University of Ottawa, and our mandate is to intervene on behalf of the public interest on policy issues arising at the intersection of law and technology. It's a huge mandate. As a technology lawyer, most of the lawyers that I speak to think that I'm incredibly specialized in what I do, but the reality is, as a technology lawyer, I'm sticking my nose into all sorts of different issues because technology cuts across all sorts of different issues. And in this presentation, we're going to talk about a wide variety of impediments to data transfers and barriers to sharing. And in addition, we're going to talk about some interesting legal structures and areas of law that potentially facilitate data transfers and may in the future do a better job of facilitating data transfers. So with that background, let me just give you a quick heads up of what we're going to do. This is think about this list of things moving from things that really wreck sharing data to things that facilitate sharing data. First, we're going to talk about privacy, and we're going to move on to IP and let's call it rights in data, how the law gets a handle of rights in data. Then we're going to talk about a particular application that I've done quite a bit of work in, which is smart cities. We're going to move from there into data governance, and then finally take a look into the crystal ball at the future, or a little bit more accurately, we're going to take a look at Bill C-11, which is legislation right before Parliament. It's an open question whether this law, which is supposed to revise privacy law, is going to actually become law. Given that we've got a minority parliament, minority government, I should say. But it gives us some view of how people are thinking about data and some of the impediments to sharing data. and what some of those legal solutions might look like. So with that background and outline, let's dive in. And first we'll talk about privacy. I'm not going to spend a huge amount of time talking about privacy because I know you've already had a session on this, but nonetheless, I think it's really useful to set the I don't know, set the framework in place because we're going to come back over and over to privacy. And think about how privacy is an impediment to data transfers. First, the commercial private sector framework that I'm going to talk about mostly is PIPEDA. If you're working within an educational institution or you're working within government, I know you've got a different framework in mind, that you generally have to comply with. But if you've got a private sector partner in place or any kind of commercial fingerprint in the data, then there's the danger of PIPEDA stepping forward. And PIPEDA is where the government is spending a lot of its time paying attention and thinking about how the law can help data transfers. So we'll focus on PIPEDA. Though a lot of what I'm going to say about anonymity and data transfers and the definition of personal information is transferable kind of across the different data protection regimes that we have at the municipal and the public sector and provincial and federal levels. And I thought, the best way to describe kind of the background and the work that we've done in this space is through war stories, right? Just kind of going over the work that we've done and giving you a sense of how we've gotten involved and why we saw the need for a public interest intervener or public interest intervention in that dispute. So I'll start with talking about one of my favorite cases, which was Philippa Lawson, which was my predecessor as the director of CIPPIC way back in the early days. This case is old because this is the actual fax we received from the federal court. They don't give out the decisions by fax any longer. A really interesting case which set the jurisdiction of PIPEDA. We'd filed a complaint in that case against effectively a data broker operating out of the United States that was targeting Canadians and selling a business about Canadians. If you wanted to buy personal information about a Canadian, they actually had Maple Leaf on their website advertising that service. So we filed a complaint about them saying none of this stuff is lawful. They were collecting and selling personal information about Canadians without their consent, without their knowledge. And it's just wrong. The privacy commissioner took a look at this website and said, yeah, we don't like what they're doing, but they're based in the United States. They're not playing ball. They're not cooperating with us in our investigation. And so we're going to say that we don't have jurisdiction. We strongly disagreed with the court's interpretation, or not with the court, with the privacy commissioner's interpretation of her own jurisdiction at that time. And we took her to federal court saying, no, sure, they may be based in the United States, but if you don't have jurisdiction over foreign businesses that are dealing with Canadians' personal information, selling Canadians' personal information, advertising to Canadians about services involving Canadians, then what good is your law? Says it a little bit strongly, but that's basically our position, and we succeeded. We won. Federal court agreed with our interpretation of the scope of PIPEDA, of our federal private sector privacy legislation. And in doing so, greatly expanded the scope of protection Canadians enjoy. Without this decision, we don't get any kind of protection against, American-based organizations that don't have a substantial presence in Canada. And in fact, as you'll hear shortly, when we went after Facebook, Facebook's response was, "We're an American organization. We're not even subject to the Privacy Commissioner's jurisdiction." They quickly backed down from that position, and largely thanks to our work on this case. Now, I mentioned Facebook. This is, I think, how CIPPIC really became kind of a well-known organization in our space. When Facebook kind of launched in Canada and really revved up its practices, we took a long time and spent a lot of resources examining exactly what they did and how they did it. and we came to the conclusion that they paid no attention whatsoever to Canadian privacy law, and in fact were in violation of PIPEDA, and we filed a complaint again with the Privacy Commissioner of Canada, asking them to go after Facebook. It was a huge case. Facebook resisted the Privacy Commissioner's investigation and findings almost every step of the way. But again, ultimately, we were largely successful in the vast majority of the complaints that we had against Facebook. And more to the point, the Privacy Commissioner found that Facebook, this big international organization, who's really, I mean, its only business was data, right? Personal information, our data, that it was subject to PIPEDA and had to abide by the commissioner's findings. This picture that you can see in the bottom corner, that is Philippa Lawson, the former director of the clinic, the one who was in the house when we first started this, this complaint, and two of our students at the time, one of whom is Harley Finkelstein, who is now one of the senior execs at Shopify here in town. So the students, we've had hundreds of students come through the clinic through the years. Now a number of them have come up through the shop and gone into fairly senior positions at pretty influential firms and businesses across the country. More of the work that we've done in the privacy space, we did a project a few years back on data brokers. It was inspired by the work that we did in Abaco way back in almost 15 years ago now. But we just did not have a good sense of how data brokers carried out their businesses in their business in Canada. Data brokers are businesses who basically sell information about individuals. That's their meat and potatoes. That's what they do. And it's a very mature industry now. It's a huge industry. When we first started looking at data brokers almost 20 years ago now, there were smaller outfits, they mostly repackaging and reselling public information. With the basically with the emergence of big data and the tools that basically all of you on this call use in your jobs, available to this industry now. The industry has really grown, and the leaders in this space basically operate. What's the best way to describe it? Maybe a commercial-facing Facebook kind of industry, an industry where where basically they offer web interfaces where you can plug in your services or your tools to extract data that they're offering for sale. Much of the data that they're offering isn't data that they've collected and they're repackaging and reselling. Instead, it's data that they themselves are developing on the basis of the data that they've collected about us. It's a massive industry, and because it doesn't face consumers, we know very little about it. From our perspective, there are huge problems with Canada's law. About the only time we ever really run across these guys is when they screw up, right? When there's a data breach, or some kind of massive unauthorized disclosure of Canadians' personal information into the wild, and that's when we get a peep into what they're doing. Privacy Commissioner has also taken a look at data brokers, but been very frustrated in their own work, finding it very difficult to basically rein these companies in. So that they have effective and useful disclosures, and get effective and enforceable consents for their activities. I don't think we've heard the last of data brokers in the not too distant future, or in the near future, and their problems with privacy law. Now, I've spoken at length about privacy law, and it's all built on the definitions of personal information, whether you're talking about PIPEDA or you're talking about some of the provincial or federal public sector privacy laws. They're all built on personal information. Personal information is just information about an identifiable individual. Now, this is a really, the identifiable part is what's really important, because that means that personal information includes information beyond the information that is merely, what's the right way to describe it? Information that on its face describes individuals. It also includes information that with a reason lead either on its own or in combination with other information to the individual, right? So the identifiable feature is huge. Another important feature of both public and private sector privacy law is this consent principle. In the federal government, pardon me, under PIPEDA, you need consent to the collection, use, and disclosure of personal information. In the private sector world, pardon me, the public sector world, so government use, you don't need consent to the collection. You basically get the right to collect information and to use it for the purposes for which it was collected. But you need consent to any kind of reuse that goes beyond that initial collection. And you also need consent to disclosures that again go beyond the purpose of the initial collection. So consent is a huge issue. We're going to come back to consent shortly. Now, these definitions are important because the primary tools by which you avoid liability under our privacy legislation for the sharing or transmission or disclosure of data that will include personal information is anonymizing that personal information or de-identifying that personal information. And it's tough to do. And I can tell you that our courts struggle with this concept. The idea is if you make personal information so that it is no longer identifiable, then you're outside of the definition of personal information and you're outside of the liability for the imposed by the privacy laws. This case, the Philip Morris case, this is a case that CIPPIC intervened in a few years back. This didn't have much, on its face, it didn't seem to have much to do with privacy law or anonymity. It was the tobacco, basically the tobacco damages legislation, whereby the provinces of Canada were suing the tobacco makers for damages for all the cancer they've caused Canadians over the years. To prove damages, the provinces were putting into court evidence of their health data, right? All the cancer patients that have come, all the chemo sessions, all of the, basically all of the health data about Canadians that they could trace back to tobacco. Now, it should be obvious to all of us that that's health data. That's data about patients, and so that immediately raises huge privacy concerns. And in fact, that is exactly what what the provinces said. We can't share this information with you, Philip Morris, or any of the tobacco companies, because we can't disclose the health information of our patients. All we can do is come up with some tricky mechanisms by which you can have confidence or challenge effectively our damages claims, while at the same time respecting the personal information of patients, of Canadian citizens. It went to the BC Court of Appeal, and the BC Court of Appeal didn't like this approach. What the BC Court of Appeal wanted to do was, look, just take their names out of it, and take their health numbers out of it, and that's all you need to do. Just strip out facial identifiers, and the privacy considerations have been taken care of. Well, if anybody's done any work in anonymization, they know that is not how you anonymize health information. That is not how you safeguard privacy in this space. And so CIPPIC, we've effectively intervened on this issue, saying, all right, we've got a situation where you've got to share health information because Philip Morris has to be able to challenge the damages claims of the provinces. But you can't do it the way the BC Court of Appeal did it. You need a more sophisticated approach to de-identification of health data. And we put to the court both kind of the let's call it the standard wisdom now on how you de-identify health data, and showed them some standards that have been adopted by legal authorities in the United States and in Canada around de-identification of health data in particular. The Supreme Court fortunately sided with the provinces in this and stripped back what Philip Morris was entitled to receive. One of the key features of a good chunk of the health data involved in Philip Morris was around location data. The huge problem, basically, the policy position that privacy advocates have taken around location data is that it is virtually impossible. It's almost impossible to de-identify data that includes location data if it's if that data can be linked to an individual. And the example that I always give on this is my own biking practices. I bike to work when I well, actually I just go downstairs and go to work. But when I went to the office, I used to bike to work. And I know that I'm the only guy in my neighborhood that bikes, from my neighborhood to the University of Ottawa. And the standard approach to de-identification of that kind of data, that bicycle routing data, is to strip the ends away. But it turns out that you've got to strip, you've got to go to a pretty high level of abstraction. You've got to, you've got to go beyond my neighborhood to kind of, my big city block, basically, probably about 10 blocks before you can have confidence that you're not going to locate me. You're not going to identify me from my commuting data, my bicycle commuting data, just because I'm the only prof that goes every single day from Westboro to the University of Ottawa. And so you're just not going to find other people with that data characteristic. And so once you've got that unique bit of location data, it's pretty easy to combine that with other data to figure out who I am. Anyways, that's the example that I often provide. And so in the Philip Morris case, there was tons of location data in the data that was being disclosed, and we brought that to the court's attention as a problem. So I promised I wasn't going to talk about privacy for a long time, and I think I just spent 10 minutes talking about it. We're going to come back to it at the end, but for now we'll move on. This kind of the second category of problems that my profession poses to yours is around intellectual property and property rights and data. Now, data is a funny thing in law. We often talk about data as an asset. It's my data. I'll share my data with you, and then it becomes our data. The truth of the matter is the law doesn't have a very good handle on data, and data by itself isn't property in the way that we think about property vis-a-vis intellectual property. Intellectual property means things like patents and copyrights and trademarks. These are shows as an action in law. It's what we call these things. They're actually a form of property. They've got the exclusive right attached to it. That having been said, data does find its way into a bunch of different little areas of intellectual property in unusual ways that raise problems for sharing data. The biggest one of those is copyright. I've done a ton of work in copyright over the years. I first got into this whole technology game by falling in love, much to my surprise, with copyright law. And copyright protects data in the form of original compilations of data. So original means a particular thing. It's not any old organized or structured group of data. It's data that's organized in an original way. And a good way to think about this is the yellow pages versus the white pages. The white pages, it's just organized geographically and alphabetically. That's not very original. That's an obvious way, a purely mechanical way to organize data. A more original compilation of data might be the yellow pages, where in fact there you've got what's better characterized as a description of the economy. So all of that data is organized not only alphabetically, but also through the use of art, through the use of layouts, through the use of a structured view of the economy. So you've got your garbage collectors in the yellow pages in the same way that you've got your ballet academies in the yellow pages. Someone had to come up with that and pull all that together. And there's a very good argument that the yellow pages, in contrast to the white pages, enjoy copyright protection. Why am I talking about the yellow pages versus the white pages? In your own data sets, how is your data structured? Is it an original compilation of data? Does it take, is it beyond purely mechanical, has some thoughts, some effort, and novelty is the wrong word, but let's just say non-obvious effort gone into how that data is structured. If so, the compilation as a whole may enjoy copyright protection, and so it's something that you've got to deal with. Distribution of another's original copyright protected compilation of data is going to violate exclusive rights under the Copyright Act, and so you're going to run into difficulties. Copyright is an exclusive right. You've got to have a permission of the copyright owner to deal with that work, and there are statutory damages. They don't even have to prove that they've suffered any harm. They can go to court and ask for a fixed sum for your violation of their copyright. Another category of intellectual property is confidential information. It's not property in the way that we think of copyright and trademarks and patents. Those forms of intellectual property are plainly property rights. That's the handle that the law uses for describing those kinds of rights. Confidential information is different. Think of it as trade secrets, and it's really a relational kind of thing. The basic rule is that confidential information is any information that is not generally known to the public and is disclosed under circumstances that import an obligation of confidence. So that's the key. It's not that the information was unknown before you got it. It's that you only got it under those circumstances that import an obligation of confidence. The formal, way that you get that is through a non-disclosure agreement or a trade secret agreement or a data sharing agreement that includes a confidentiality obligation. But there's nothing formal that the law requires. The law simply requires, a sharing of data under those circumstances that import an obligation of confidence. So just an email saying, this is confidential information, don't share it beyond. That's all that the law really requires to impose that confidential relationship. And violation of the law of confidence is very easy. Any use other than a permitted use is a misuse, and that's all the law requires to make it actionable. The remedies under breach of confidence law are very flexible. So this is an area that is often kind of not paid adequate attention to. Many of these areas of law, things only really become a problem when things go off the rails and disagreements arise. However, that doesn't mean that these aren't significant impediments to data sharing obstacles. It's important to realize that anonymity is not a solution here. This is not a privacy issue, right? So this really is having the permissions that you need in place to deal with the personal information, not personal information, to deal with the data itself. And it's important to realize that, the permission, it doesn't necessarily come from the person who shared it to you, right? It's the person who effectively owns, putting owns in quotes, the data. So that data can be shared with a third party, and that third party can then share it with you. If they didn't have permission to to engage in the initial sharing, then they're obviously in breach. But more to the point, you don't have the permission you need to use that information. So confidential information can be kind of a tricky area of law that has to be dealt with. Generally speaking, in intellectual property, we've talked about permissions and exclusive rights. How you deal with those is by getting a license. The licensing. License just means permission. And so the easiest and let's say risk addressing means of accommodating intellectual property issues is through licensing. Now, we at CIPPIC, we've done a ton of work on licensing over the years. We were the ones that translated the Creative Commons license into Canadian law way back in the day. And we've worked with Creative Commons over the years in translations and in providing advice on how to do open licensing in the copyright space, which is what Creative Commons deals with. But we've gone beyond creative licenses and Creative Commons licenses and dealt with open licensing more generally. Certainly in the open source software space, we've done a ton of work, but also in the data space. So, here's just a little clip from the webpage of the Open Government License in Canada. We've done a ton of work over the years on licensing, particularly open data licensing. with a view to promoting interoperability and combination of open data sets. There's a ton of tricky ways that open licenses aren't as open as you think they are. And the major way that open licenses don't do what you think they're going to do or don't do what you want them to do is through incompatibilities. And just a simple example, the example is the deadly jurisdiction clause. You can have a tremendously open license, that says anybody can use this data for any purpose that they want for, without doing anything, without even having to use this license, except if if the license has a clause in it that says that any disputes have to be dealt with in Canada. That's a huge problem, because if you're trying to combine a data set under that license with another data set that's got a similar jurisdiction clause, that says any dispute has got to be resolved in Great Britain or the United States or Antarctica, then you've got a conflicting jurisdiction clause, you've got incompatible licenses, and you've got a barrier, much to the frustration of all parties, a barrier to being able to combine those data sets and make the data interoperable. Just at law, it hasn't been done. We've also done some interesting work. And we actually did this work with Peter's group at Carleton, looking at open licensing schemes for traditional knowledge. Traditional knowledge is one of those funny areas in Canadian law where we don't really have a law protecting traditional knowledge. There have been lots of proposals over the years, to create a sui generis or a new area of intellectual property like law to grant traditional groups some form of protection for traditional knowledge, and they haven't really borne fruit. But yet, at the same time, we have seen a great deal of interesting work and progressive work happening from other groups. I think we've already talked about OCAP at some point today, and probably in the prior presentation in this program. So OCAP is one of those principles that operates outside of the law, that effectively operates in a normative fashion, right? It really talks about how you should behave when you're dealing with Indigenous groups information, with Indigenous groups data. The proposal that we came up with working with the group at Carleton was kind of a belts and suspenders approach. It said, okay, if you want to access kind of traditional knowledge or knowledge coming from, an Aboriginal group or First Nations group, yes, you've got to deal with privacy. Yes, you've got to deal with intellectual property. Yes, you've got to deal with specialized areas of law. But even if all of those fail, even if the data you're dealing with isn't protected by copyright, even if there's no privacy involved, even if there's no, other forms of protection available, to the First Nations group, nonetheless, there's a normative component where the parties are agreeing that this is how they're going to behave with respect to this information. And generally speaking, that's in a manner consistent with OCAP. So it's a real belt and suspenders approach. You've got, trying to grab intellectual property laws, trying to grab contract law, and also trying to grab kind of non-law but normative regulators of behavior to achieve a just outcome with this data. It's a fascinating piece of work that we've done and that we did with the guys at Carleton, and we've always meant to come back to it and see if we could kind of move that scheme forward, and who knows, maybe something for a post-pandemic life. So we've talked a lot about funny and unusual areas of intellectual property. Here's another one. There's actually a database right in Europe. It's not in Canada. It's not in the United States. But nonetheless, if you're dealing with people based in data sets based in Europe, there may be this additional layer of liability involved with extraction of data from a protected database under this European directive from 1996. Right, so that's kind of a long background of all of the kind of not it's not even all of the many of the ways. We haven't even talked about contract law and how contract law can foul you up here. But I thought it might be practical to talk about some of the smart city applications where we see these impediments to sharing. Raising issues, and for good reasons. Some of them are for good reasons. Nonetheless, I think the smart cities context, as you'll see, has actually motivated our government to start to figure out some approaches to addressing these concerns. So yeah, we've done a ton of work. I'm just going to give you a kind of a quick overview. The most recent piece of work we did was a smart city toolkit with with Infrastructure Canada. This is kind of a little kind of a mini book that we wrote last summer, dealing with all sorts of ways in which Canadian municipalities can kind of get into the smart city game. The value add here, I think, was identifying not only kind of the areas of law and really practical smart city applications that Canadian municipalities can get involved with, but by looking at kind of the issues. We describe these as meta issues that kind of recur time and time again. Um, in dealing with smart city technologies and smart city applications. And look, there's some of our interesting and familiar friends, privacy and intellectual property showing up there. Security issues pop up. Those are the obvious ones. Procurement, a little more specialized for those in the municipality and I guess provincial, well, I guess even federal government game. But interestingly as well, we did a lot of work on inclusion in this, thinking about ways in which smart cities can be more inclusive cities. It was a lot of fun. We had a great time doing this work. But it's far from the only work. That's just the more recent work. We've actually put a ton of time and energy into working on smart city privacy here. This is something we put out in January of 2019, which really looks at the mess that is privacy jurisdiction in the smart city. Looking at all the ways in which federal, municipal, provincial, and private sector privacy laws can get in the way of smart city initiatives. It was quite a tangled web once we really started to drill down into it. Other work we've done in this space, Sidewalk Labs. This is what shows up when you look at Sidewalk Labs' old office in Toronto. It's fittingly now closed. We were involved. Let's just say behind the scenes is probably the best way to describe our work here. Trying to be an honest broker. We were really of the view that, and we still are of the view that there is going to be some kind of, let's describe it as an innovation forum in this section of Toronto, which is going to be looking at smart city applications and looking at kind of city as a platform type approaches to the provision of municipal services and the bringing of the private sector into partnerships with the municipality and the province and even the federal government in providing municipal services. And so we're far from done, I think, with this. But the Sidewalk Labs was like, I always have a difficult time describing. Let's just call it the imbroglio. That's probably the best word I can come up with. The Sidewalk Labs imbroglio really, I think, spurred a lot of innovation and policy innovation about how to think about data in the municipal context, and in particular thinking about data sharing. And it moved us into doing a ton of work in the data governance space. The licensing work that we did before, the open data work, that's all a species of data governance. But I think the Sidewalk Labs imbroglio brought data governance issues to the fore. It inspired us to do a ton of work on data stewardship models, in particular, looking at proposals around data trusts. And our own view is that data trusts became kind of a tool. We actually described it as trust washing, where if you call a data governance vehicle a trust, it must be trustworthy. It must be a good thing. The reality, I think, is you've always got to look long and hard at a data governance model to understand how the interest is defined, the interest in which the trust vehicle operates. How does it determine what is a positive use of data and whose interests it's going to use that data? My colleague Teresa Scaza, who presented earlier in this series, did an exceptionally good piece, I thought, looking at smart meters. I'm not sure if she talked about smart meters, but looked at smart meters and how kind of the benefit model for the use of all of our data from smart meters has evolved over time, moving from a very secure, privacy-focused approach to one that basically opens the door to private sector use of that data, not for profit per se, in the sense of building profiles or selling that data, but instead for research and development, methods. So private sector, all these smart tools that we're seeing, smart home thermostats and smart monitors and all these kinds of things that are all being built on the data, on our data, through the trust model that we've seen evolve in the smart meter space, and how that model has kind of expanded and the uses have drifted over time. All of which fed into our analysis of data stewardship models, saying that just calling something a trust doesn't get you there. Instead, it basically just calling something a trust basically just hides the hard work that you have to do in defining the interest in which the stewardship model is going to work. And really, I mean, looking at how these things are funded is crucial. And anonymity, again, it keeps rearing its head in this presentation. Anonymity is the grand solution to data use in the smart city. How, because if you think about what a city does, a city is effectively, it's all about movement of people through space and time in a community, right, in a defined geographic space. And so the privacy issues associated with data collection in a smart city are obvious, and they're incredibly difficult to deal with, particularly when you consider how much of the smart city data is associated with locale, right, with geographic data. Again, raising that issue I advised earlier about, that where certainly kind of the public interest folk in the data space see it's almost impossible to do an effective job in anonymizing data that includes geographic information associated with individuals, even if you're trying to anonymize the individuals. And our privacy regulators have been busy in this space as well. So right here on the screen, it's a publication put out a decade ago now by Anne Kavukian, who was then the Privacy Commissioner of Ontario, basically going to war with, well, that's stating it strongly, battling certainly in the academic space with some of the privacy advocates I was talking to earlier, who are having a difficult time appreciating how anonymization strategies were going to be effective in de-identifying individuals, in removing the likelihood of re-identification. So we see this publication in 2011. More recently, we've seen movement from our regulators from kind of advancing de-identification to articulating standards for de-identification. So I talked earlier about our intervention, Philip Morris, looking to standards in the health sector, whereby health information is shared with researchers working on drugs or working on treatments in an anonymous way. Those are built on standards that have been recognized by regulators in the space. And we've seen our Canadian regulators do the same thing. So here, this is in June 2016, largely a response to Sidewalk Labs, the Information Privacy Commissioner of Ontario putting out guidelines for structured data, basically putting together a how-to kit. How do you de-identify data in a way that pulls out the risk of exchanging personal information, and so pulls away from the privacy risk associated with this. Now, this is just a privacy data, but you can see similar approaches maybe involved in the privacy space, but also in the intellectual property space, standards and guidelines in the security space, standards and guidelines for agreements, data sharing agreements. So these are all different ways in which this particular approach the guidelines, the standards, the regulator's stamp of authority might be used in a way to reduce risk in data sharing and to kind of to advance goals of interoperability and data sharing. Which takes us to the final little piece in this presentation, which is looking at the future. Now, I don't propose to do a comprehensive peer into the looking glass. Instead, we're going to look at something that's immediately in front of us and something focused on privacy, because I think it reflects a lot of what CIPPIC, what I've learned in my last 2 decades working in this space. And I think there's some hope. I think there are some lessons learned. And if we do it right, I think this can be, some of the issues that are being proposed or some of the solutions being proposed are a step forward. I don't think it's exclusively a step forward. I've definitely got some concerns with the legislation, which we'll talk about briefly. But there is some good stuff in here. So what am I talking about? I'm talking about Bill C-11. This is an act to enact the Consumer Privacy Protection Act and the Personal Information and Data Protection Tribunal Act, and to make related and consequential amendments to other acts. What this law does is it updates PIPEDA, our private sector privacy legislation, and creates a Data Protection Tribunal Act, so a regulatory authority. And it fixes some of the problems that we've identified that are particular to privacy and data. First, let me talk about de-identification. There's an interesting little bit in the legislation, section 74, it says an organization that de-identifies personal information must ensure that any technical and administrative measures applied to the information are proportionate to the purpose for which the information is de-identified and the sensitivity of the personal information. Now, this is a view that de-identified data can be shared. So it tries to attack that critique, that says that any information, it can be any anonymized information can be easily re-identified, and so you've got to be really careful about sharing anonymized data. This provides organizations with some cover, and it says that if you've got really sensitive information, you've got to use really high-level technical and administrative measures in order to de-identify that data and to be able to share it. But if the information is unimportant, not particularly sensitive, then more rudimentary levels of technical and administrative measures might be applied. The legislation doesn't identify what technical and administrative measures might be, and so it leaves that as an open question, which it might address through another mechanism, which we'll get to shortly. There is also a prohibition there closely related to that de-identification standard. It says an organization must not use de-identified information alone or in combination with other information to identify an individual, except in order to conduct testing of the effectiveness of security safeguards that the organization has put in place to protect the information. So some limitation there. Now, an area of the legislation that I think is really interesting is sections 76 through 81. These talk about codes of practice and certification programs. This says that the regulator can encourage and give approval to these certification programs and these standards, but it does not provide a safe harbor. So a safe harbor says that if you abide by these, this standard or this approved process, then you will not be liable. This is not that. Instead, this is the government throwing a bit of shade. That's probably the best way to describe it. Throwing a bit of shade over organizations that try and act in an organized and responsible fashion. A bit of shade between the hot sun of liability for privacy violations and useful sharing and I guess making data sets interoperable. It's an interesting approach. This idea that a group can come together and create a standard, much like the health information standard we spoke about earlier, take it to the regulator and ask them to approve this standard or certify this certification program. So it's an interesting approach. It's kind of a half step towards a safe harbor. The other thing that the legislation do that's interesting and somewhat problematic is it eases the burden of consent. So we spoke earlier about how privacy law fundamentally requires a consent to the collection, use, and disclosure of personal information in the private sector context, anyways, and in some circumstances, even in the public sector. There's a burden for consumers, certainly, because it's almost impossible to understand what private sector organizations are doing with their information, given the technical nature of privacy policies and how they hide what we're doing. It's if we actually had to read and understand all of the privacy agreements we agree to, we would not have time to do anything else with our lives. So plainly, there's a burden. And what the legislation tries to do is say in kind of obvious cases, cases where a consumer would obviously not disagree, we're going to ease you of that burden. Unfortunately, the burden ease is pretty broad. So the legislation talks about the ease of use of personal information for business purposes, and it doesn't really define what that is. And so there's a real problem with that. That's potentially a huge area. I think the intent is kind of the obvious purposes for which a business is collecting your information. If you to really date myself, I gave my personal information to Blockbuster Video so that I could rent videos. It's fairly obvious that that's what they were doing, and getting my consent to that activity, while relatively easy at the time, was just one step that wouldn't necessarily need to be done. Now let's think about the last little section that I wanted to raise to your attention. This is section 39, which permits disclosure without the knowledge of consent of individuals where that disclosure is for a socially beneficial purpose. That socially beneficial purpose is defined as a purpose related to health, the provision or improvement of public amenities or infrastructure, or the protection of the environment, or any other prescribed purpose. So very broad definition, and it's a tough call as to what's going to be in and outside of this definition at this point. Another interesting piece of it, though, is who the disclosure must be made to. So it's not any disclosure; it's instead disclosures to specific authorities. One is government. Second is health authorities, but the third is this interesting construction. Any organization that is mandated under a federal or provincial law or by contract with a government institution or part of a government institution in Canada to carry out a social beneficial purpose. I'll just ask, is that supposed to be a data trust or a data steward model? Theoretically, it is. Looking back at that definition, it's an organization that is mandated under a federal provincial law or by contract with the government institution. So there's got to be that connection to the government. But it doesn't necessarily have to be a creature of statute, right? It can be something that can be crafted for that purpose. And this really brings to mind the data trust suggested by our good friend Sidewalk Labs in Sidewalk, Toronto. And that brings me to the end of all the things that I do that wreck what you do. I'd had a couple of questions prepared, for the discussion, though I wouldn't want in any way to restrict the discussion to these two questions. But the ones that I had in mind were, are the risk factors identified in this presentation actually encountered in your field? I mean, am I right in saying that I wreck your life? If so, If so, how do you manage those risk factors? And then the second piece is the solution proposed in our privacy space, our standards, approved guidelines, and data stewards, the best approach to data transmission and interoperability risk. Or is this just the latest, the latest flavor, and that there are other mechanisms that are better used for addressing risk? And that was everything. Thank you.
All right. Thank you, David. So I've put your questions into the chat, and I'm ready with breakout groups. We're making them a little bit larger this time around just because we've been experiencing drop-off in members. Let me just double check that we have. So hopefully you'll have enough people for a good conversation in each group. 15 minutes again, then we'll come back to plenary for a wrap up. Have a good discussion, and we'll see you back here shortly. All right. Welcome back, everybody. Here are the true warriors left in the room. So what would you like to bring back to the large group, either in terms of questions or comments? Or have we managed to exhaust everybody?
Hi, this is Birger speaking. David, I was giving you a question before I got booted out of that room. So I think I finished the question. I don't know if you would like to share your response. I did discuss it with the group I ended up with.
Could you maybe repeat the question for us, Birger?
Yeah, it's actually typed in the chat, but it's basically I'll just read it. It says, given resources available to companies reliant on database business models, isn't developing law standards and enforcing them always going to be a losing battle, especially when dealing with foreign firms, sometimes supported by bad state actors where laws are generally irrelevant? Should we not instead focus on a cost-based model where individuals have complete ownership of their data, and we provide a legal framework for people to monetize their information? It's a bit of a mouthful, but David, I think you know what I'm talking about.
I do, yeah. There's been some really interesting proposals for just kind of reshaping privacy law effectively, so that it is much more of a property-based system that explicitly benefits data subjects, or each of us, the people who are generating the data in the privacy space. Privacy is a weird law, right? It doesn't. It's not property in the same way that we think about copyright and other forms of intellectual property rights as property. But yet at the same time, there's plainly a permission-based system. If you use personal information without getting consent to the collection, use, and disclosure, you're going to violate it. On the flip side, we didn't even talk about this in the presentation. The complete absence of any really kind of effective remedies for violation of the privacy law really makes all of us vulnerable to not only to bad actors, those who violate the law, but good actors who take advantage of the law and how it's been interpreted over time. So, I mean, my response is, yeah, I'd love to see us move towards some of the more adventurous models of personal data stewardship and control over our data, including mechanisms to monetize it that we've seen. Tim Berners-Lee's announced, has proposed something really interesting recently. I don't know if anybody's taken a look at that. That's a separate presentation in and of itself. But it's complicated and it's difficult. And unfortunately, it's not something that seems to have captivated the attention of our lawmakers. So making that kind of radical change in the law, even though it makes a certain amount of sense, doesn't seem like it's something that's up for grabs in the near future. Maybe a private sector solution. Like you can imagine some private sector organization providing a service. Here's how you monetize and control your personal information. And if that catches on, other organizations could link into that, and kind of, potentially even seamlessly, right, using an API to access and basically through a virtual handshake, exchanging data and exchanging compensation. But we're not there yet.
All right, thank you. Any other comments or questions? Peter, go ahead.
Thanks for a great talk, David, and great to see you again.
Yeah.
I've been through a hiring process. I got exposed to some really interesting work coming out of the GIS sector on geoprivacy, particularly thinking about a scholar, David Swanland, a young emerging scholar out of Simon Fraser. And they're developing softwares. Mask.xyz, I think, is one of them, and starting to get really into this from the technical level. I'm wondering if you're seeing any of that start to sort of morph into the legal world, into sort of any of the work that you're doing, like in terms of tools that you can actually use to deal with what you pointed out a number of times and I'm interested in, which is the location policy.
Yeah, that's while I was just, in response to that last question, I just said kind of like technological solutions aren't there yet. The truth of the matter is that one of the things that I would like to see in our revised privacy legislation is in giving kind of what's the best way to describe it? Let's just say enforcing self-help rights. So the example that I often give is third-party cookies. There are lots of tools out there that allow me to download a browser helper object that sets my cookie preferences into the browser. And so any website that I visit can just read my browser and say, oh, this guy doesn't want third-party cookies. And so I don't have to worry about negotiating, setting my cookies, which we all have to do with every website we visit nowadays. The problem with that is any website can ignore that without any kind of liability. What if we flip that? What if we said that, if we adopted a tool that met, that had been certified or met a standard that disclosed our preferences around our personal information, what if we made that enforceable? What if we made anybody who ignored that a violator of the law? That might do a lot to promote the kind of technological solutions to privacy that I think will actually be effective and will actually help address some of the concerns that we've talked about here. Because I think technology can do an awful lot more to protect people's privacy and at the same time promote access to data, in really useful and effective ways. But we're not, we're not, what's the right way to describe this? We're not promoting those approaches in our legislation at this point. And so, more stuff from the private sector, more stuff from the academic sector, but without the force of the law behind it, unfortunately, the Facebooks of this world are never going to be convinced to abide by our preferences. If they can circumvent our tools to get what they want, then they will. And if they can do so without any kind of liability, then they already are doing it.
Yeah, thanks. And in our group, we talked a lot about substantial liability, given the size of these companies. The fines or whatever the case may be have to be significant enough for them to bother to care. So. Yeah,
I mean, I haven't fallen down the rabbit hole of remedies in this presentation, but the remedies on privacy have historically been wholly inadequate. I mean, the reality is that I think we only began to see real attention being paid to even something as simple as safeguarding personal information, dealing with data breaches, once data breaches became fair game for class actions. As soon as the class actions entered the field of play, all of a sudden companies became much more motivated to adopt appropriate safeguards to personal information, which is an obligation already in the law, right? So I'm not talking about something new. This is something they were already supposed to do. So I absolutely agree. Real enforcement at scale is what will get businesses to take privacy seriously, and the kind of tools that I think the technological tools that can make a practical difference, given the force of law. You've got to comply with a stated preference, through a tool that can be effective.
Okay. Thank you. Dan, you have a hand up. Please go ahead.
Yes, thanks. So I have a question, and it kind of relates more to the public sector. So I am with the public sector organization, and actually working with 3 public sector organizations who we're trying to share information. The federal government's moving largely towards what they call a tell us what once approach to collecting information from individuals, and we've been given a lot of guidance in terms of, try to be more client-centric, don't ask the same people for the same information more than once. And this is kind of the model that they've used in governments like Estonia. But at the same time, the current Privacy Act doesn't support this approach at all. And I know there's some recognition of this fact, and they're looking at amending this. But the fact is, right now, departments can't even share information with each other with consent. And I've gotten this opinion from Justice Canada, and they've stipulated that Section 4 of the Privacy Act requires that departments have to have authority to collect information before they can share the information. And if the information is not related to your mandate, then it doesn't even matter if you ask for consent, you still can't share it. So what do we do about that? Because it doesn't feel like it's serving anybody's interests to ask the same person who's dealing with the same 3 organizations for their address 3 times.
Yeah, this is interesting stuff. I mean, first of all, the legislative barriers are well understood. The Privacy Act is old, right? It is creaky. It is past. In fact, I think they're undertaking a consultation right now on revising the Privacy Act. So that suggests that maybe this government is thinking about doing something there in the not too distant future, which can help address that. The big problem we have with dealing with silos within government, data silos within government, is that historically that's been looked at as an advantage as opposed to a liability. Government is looked at somewhat skeptically, and government shouldn't have more information about us than they need. Government shouldn't be sharing information across departments. My tax information should have nothing to do with my health information, should have nothing to do with my sporting information, all different sectors of government activity that might have data about myself. And those of us who've done some work in civil liberties, which is an area of our activity that I've completely left off this presentation, but we do a lot of privacy work in civil liberties. Are always very cautious about opening up the floodgates to government access to personal information. Those who are asking for the information, absolutely do so with the best of intentions. But there's 2 things that are always true about government mandates. One is function creep. The information that's gathered today for this purpose tomorrow can be repurposed for something else, and there will be an effort to do that at some point. And then the second thing is misuse at some point. Misuse is a strong word, but I've had conversations with, it's something that I always bring up, actually, conversations with privacy commissioners from all over the country. I always ask them how many complaints they get about police officers who are misusing their databases to find out information about young men who are dating the police officers' daughters. And it always happens. Just to raise the point that misuse will happen, and misuse arises in the confidential information sense of the word, right? It's a use other than what is permitted. But we have a system of checks and balances with respect to government action for a reason. What I might regard as a misuse, the misuser would say that's absolutely fantastic use, and that's something that we should be doing. But that's not the system we have. We have a system of checks and balances. So this is a very convoluted way to respond to your question that says, yes, it's a recognized problem for those who want to do good within government, but it's not easy. It's not easy to overcome because of the need for checks and balances and the reality that a little bit of sand, oil, isn't a bad thing when it comes to government use of citizens' data.
All right.
Thank you for that.
Thank you, Dan. And on that note, I will bring this event to a close and invite Margaret to say a few words about maybe Thursday's event.
Thanks, Lise. So first off, thanks to all our speakers, Anne-Sophie, Peter, and David. You had interesting, thought-provoking presentations, and looking forward to hearing you and with others on the panel on Thursday. I'd also like to thank Lise and Louisa, whose hard work makes this event and the related report possible. So there will be a report from this. Give us a little time to put that together. I enjoyed today's session. On Thursday, we have the final of the 4 sessions in this forum. The presentations will be on legal and practical considerations in the creation of gated data repositories, and then a panel discussion with all of the speakers from today and tomorrow. So a lot of scope for some pretty wide-ranging and interesting conversations there. So I just invite you back for that. J'espère que tout le monde a apprécié la session d'aujourd'hui. Merci à vous tous d'être venus, and thank you all for coming. Enjoy your evening.
Merci, bonne soirée.
Bye.
Thank you.
Thank you, David.
Thanks very much, David.
All right, good to go?
I think so. Thanks. Louisa, did you pass out with the statistics in the first session, or are you still with us?
I got a text.
I'm getting a little hate.
Sorry, I should have warned you. And Sophie is a lovely person, but she does love her numbers.
Oh, I'm so glad she does. I just don't.
Somebody has to, or there'd be all these unloved formulae out there, and they'd run rampant, and it would be bad for society.
Yeah, I'll be listening to that presentation again to make. I took some notes, but I don't know what they're worth. I'm gonna have to listen to that one again.
Well, and remember, she did say that you're welcome to go to her, and don't feel free to lower the level of granularity on that one. I believe she said we could share her presentation. I'm going to have to check that.